Pause. Welcome to episode 2. This is a discussion of chapter 2 of UAE crypto litigation, available at www.uaecryptolitigation.com. Welcome to the deep dive. Today, we're really getting into a fundamental legal challenge, something anyone dealing with crypto assets in the UAE needs to understand. What actually happens when money changes hands for crypto investment, but, without any formal paperwork?
Exactly. And that's our mission today for you, the listener. We want to frame this core legal problem. You see, when there's a transfer of funds, maybe to someone who's meant to manage it, there's this huge immediate risk if it's undocumented.
What kind of risk?
Well, the big question is, was it a personal loan? Something that just has to be paid back no matter what happens in the market? Or was it an informal investment, meaning the capital's actually at risk and the manager's only really liable if they mess up, like failing to make the trade?
And that classification is everything, isn't it?
It determines everything. Loan means repayment. Investment means market risk applies.
Okay, so that's the crucial ambiguity. If the investment goes sour, loan versus investment decides who bears the loss. To see how UAE courts tackle this, we're diving into a key judgment, one from the Abu Dhabi Court of First Instance back in 2022.
Right. This case involved quite a significant sum transferred between two people, and it basically became a clash of stories.
What were the competing narratives?
Pretty straightforward, actually. The claimant wanted their money back, saying it was just a personal loan repayment due. The defendant, who received the funds, argued, no, this was specifically for investment in his digital currency portfolio.
So one side claimed zero risk for themselves. The other claimed the investor took all the market risk. Classic dispute.
Absolutely.
Now, before the court could even get to that core question, loan or investment, I understand the defendant tried to, shut the case down early with some procedural moves.
Yes, that's right. A common legal strategy, like try for a technical win before arguing the substance. They raised two main procedural defenses.
Okay, what's the first one?
First, they argued the claim was too late, time-barred. They invoked the statute of limitations, specifically the shorter one under the commercial transactions law.
And the reasoning for that?
Their argument hinged on the fact that a check was involved. They said, because there's a check, a negotiable instrument, it's a commercial matter, so the shorter time limit applies, meaning the claim was filed too late.
Interesting angle. Trying to use the payment method to define the whole transaction, was the court convinced? Could a check technicality just end the claim?
No, and the court's reasoning here is really important. They drew a very clear line. The court stated that the claim wasn't based directly on the check itself. It's the source of the obligation.
Okay.
Instead, the check was just evidence of an underlying obligation. The real basis was the agreement, the transfer of funds itself.
So the court looked past the instrument to the underlying deal.
Precisely. They focused on the civil agreement to transfer funds. And by doing that, they determined the case fell under the ordinary statute of limitations in the civil transactions law, which is longer.
And that effectively knocked out the defendant's main time bar defense. That seems like a crucial step to ensure these informal agreements can actually be examined fairly.
It was. It kept the focus where it needed to be. Then came the second defense, res judicata.
Which basically means the matter has already been judged.
Exactly. They argued this whole dispute was already settled in a previous legal action back in 2019.
If that were true, the court would indeed have to dismiss it. How did they address that claim?
Well, the court rejected this defense too, and for two solid reasons. First, just on the facts, the checks used as evidence in this case were different from the ones in the 2019 case, so different evidence.
Okay, that alone seems significant.
It was. But maybe more importantly, the court found that the merits of the dispute, the core issue of loan versus investment, were never actually decided in that earlier 2019 case. Because that earlier action, which was an appeal of a payment order, got annulled purely on a procedural point. It wasn't about the substance. It was about someone failing to swear a required oath.
I see. So because the fundamental question wasn't judged on its merits back then, res judicata couldn't apply now.
Correct. The current claim could proceed.
It's fascinating how thoroughly the court addressed those defenses, ensuring procedure was followed, but ultimately clearing the path to the main issue. So here's the really interesting part for me. With the procedural hurdles gone and two conflicting stories, how did the court figure out what actually happened? Loan or investment?
This is where things took a decisive turn, based on the defendant's own words. The court looked back at the records from that prior 2019 legal action.
The same action used for the res judicata defense.
The very same. And in those records, The court found a binding judicial admission made by the defendant himself.
An admission? What did he admit?
He had stated conclusively that the claimant had given him a specific sum of money back in 2018. And crucially, he stated the purpose was for investment services, specifically buying digital currencies, which were to be held, quote, in the former's portfolio.
Wow. So his own statement, made in a different legal setting, became the key piece of evidence against his current argument. It established both the amount and the purpose investment.
That's exactly right. The court used his own prior admission to classify the transaction definitively as an investment agreement, not a loan.
Okay, so it's an investment, but the claimant still wanted their money back. What happened next?
Well, having established it was an investment agreement, the court then looked at performance. Did the defendant actually do what he was supposed to do under that agreement?
And did he?
The court found a clear breach. The defendant couldn't return the principal amount, and critically, he couldn't provide any evidence at all that he had actually purchased any digital currencies for the claimant since 2018. None.
No proof of trade execution, no audit trail. That sounds like a complete failure to perform the investment duty.
It was a fundamental breakdown. And under the UAE Civil Transactions Law, specifically Article 272, this failure triggered certain rights for the claimant.
What rights?
Article 272 allows the party who hasn't received performance to either demand performance or, importantly here, to demand rescission of the contract. The court interpreted the claimant's demand for their money back as effectively a demand for rescission.
Okay, and if the contract is rescinded, what's the consequence?
Rescission means restitution. The goal is to put both parties back in the position they were in before the contract was made.
So back to square one.
Exactly. And since the defendant couldn't prove he performed the investment duties, he couldn't show the money was invested and subject to market risk, or lost, the court ordered him to repay the full principal amount.
So ironically, even though it was deemed an investment, the failure to prove performance of that investment led to the same outcome as if it were a loan getting the principal back.
Precisely. The lack of proof effectively converted the outcome back to a simple return of capital. For more details on this judgment, of course, you can find it analyzed in the book UAE Crypto Litigation, available at www.uaecryptolitigation.com.
That's a critical lesson. Now, this case originated from events in 2018, judgment in 2022. The UAE's regulatory framework for crypto, for virtual asset service providers, or VSPs, has matured significantly since then. If this same situation happened today, the informal arrangement, holding funds in the portfolio, no proof of trades, how would regulators view that, assuming the defendant was acting like a VASP?
Oh, the view today would be, well, extremely serious. Under the current, much more robust regulatory landscape, those facts would likely point to multiple breaches of VASP duties.
Where would the first red flag be?
That admission holding assets in the former's portfolio, that immediately suggests commingling, mixing client assets with the manager's own funds.
Which is a major violation under current rules, isn't it?
Absolutely forbidden. Regulations, for example, from the SCA, demand strict asset segregation. Client crypto assets must be kept totally separate, identifiable, usually in dedicated client wallets or accounts. Commingling is a fundamental breach of fiduciary duty and client protection rules.
Okay, so commingling is a big one. What about the failure to prove any transactions happened? That key point in the court case.
That points directly to what regulators would see as a massive operational and technological failure.
How so?
Current VASP regulations, like SCA rules around wallets and custody, mandate detailed record keeping and traceability. Licensed VASPs must have systems to track the source, destination, and execution details of every single client transaction.
So things like transaction hashes, wallet addresses.
Exactly. Transaction hashes, public keys, confirmations from exchanges. If you can't produce that evidence, you've failed to maintain the mandatory audit trail. It suggests your systems and controls are just not compliant. It's a major operational red flag.
Right. And finally, just the whole informal nature of it, taking a large sum to manage in the portfolio. How does that fit with today's requirements for licensed VASPs?
It doesn't fit at all. The modern framework demands proper institutional governance. Regulators like the SCA, the Central Bank, VAR in Dubai, they require licensed VASPs to have comprehensive frameworks for risk assessment, technology risk management, internal controls.
Formal procedures, checks and balances.
Precisely. Ad hoc, informal management of client assets is completely incompatible with those standards. The rules are designed to ensure resilience, security, and auditable processes, none of which seem present in the case facts.
So, putting this all together, what does this mean for you, the listener? If you're managing assets or perhaps you're an investor using someone's services, what are the key actionable takeaways from this case to avoid ending up in a similar mess?
The absolute core lesson is that ambiguity is your enemy. Any lack of clarity, especially around whether it's a loan or investment, creates massive liability risk. So, based on the analysis, we can outline 3 critical preventative measures. Think of them as essential components for your transactional architecture.
Okay, let's break them down. What's number one, the starting point?
Number 1 is explicit characterization. This is foundational. You need a written agreement that immediately and clearly states this is not a loan, no debtor-creditor relationship.
So define it clearly.
Yes, define a precise investment mandate, what the manager can and can't do. And crucially, include a clear, binding acknowledgement from the principal, the investor, that their capital is at risk. They need to explicitly accept that the manager doesn't guarantee performance or protect against market losses. That legally shifts the market risk.
Got it. Explicitly define it as risk capital, not a loan. That's number 2. This sounds like it addresses the proof problem we saw.
Exactly. Number 2 is the trade execution and confirmation protocol. To counter that failure of proof that doomed the defendant, the contract must mandate a clear, binding audit trail, preferably cryptographic proof.
What does that mean in practice?
It means the manager's performance isn't just assumed. It has to be proven. The contract should require them to provide verifiable evidence, things like transaction hashes, public keys of the destination wallets, ideally shortly after each trade is executed. This turns the abstract duty to invest into concrete, verifiable actions recorded on the blockchain or exchange records, evidence a court can actually rely on.
Makes sense. Proof of performance built into the agreement. And number 3, this seems linked to the commingling issue.
Yes. Number 3 is the segregated asset and wallet protocol. The agreement must mandate complete separation of the client's assets from the manager's assets.
How is that usually achieved?
Often, it requires using a dedicated wallet, maybe called the principal's wallet, that holds only the client's assets and is clearly designated as such. This protocol ensures title and control remain clearly with the principal. It strictly prohibits commingling, and it provides a much clearer path for recovering assets if things go wrong.
Those 3 points seem incredibly practical: clear characterization, proof of performance, and asset segregation. It really paints a picture of robust transactional design. So the underlying lesson here seems pretty clear, right? If you don't have that clear documentation, that explicit risk allocation, and especially that proof of performance, UAE courts are likely to use basic civil law principles, breach of contract, rescission, restitution to effectively force repayment of the principal.
That's the default outcome in ambiguity. Failure to prove the investment was performed often means the court treats it like a refundable sum. You risk having your investment reclassified as a de facto loan repayment if you can't evidence your actions. And this focus on classification and proof leads us directly into the next area the author explores. They set up the bridge to the next chapter like this. The preceding analysis established the legal distinction between a loan and an investment based on a party's own admissions, affirming that a failure to perform investment duties leads to restitution of the principal. The judicial inquiry now moves to a more nuanced level of characterization. Where a transaction is clearly an investment, what is the precise legal nature of the relationship between the investor and the manager? The following case dissects an arrangement where the court was required to determine whether an individual was acting as an agent for a corporate entity or as an independent investment manager, a distinction with profound implications for assigning liability when the investment fails.
That brings us to the end of our discussion on Chapter 2. This chapter's structure analyzing the legal problem, judicial outcome, regulatory considerations, and practical mitigation is the standard methodology used throughout the book.
Authored by Mahmoud Abu Wassel and drawing on analysis from over 100 judgments, UAE crypto litigation serves as an indispensable resource for those in the digital asset industry.
To read the full analysis for this chapter and to explore the complete 7-part life cycle of a commercial dispute covered in the book, please visit www.uaecryptolitigation.com.
The discussion in this deep dive is for educational and informational purposes only and does not constitute professional advice or any other professional relationship. Please consult with a qualified professional for advice tailored to your specific situation.